Over the weekend, it emerged that a convicted paedophile and illegal migrant from the Democratic Republic of Congo, who has been in the UK since 2008, escaped deportation. The man was convicted of sexually abusing his own stepdaughter as well as 2 other young girls in his family, yet has escaped deportation after completing a prison sentence owing to, yes, you guessed, the European Court of Human Rights. This criminal was never granted asylum, but given leave to stay in 2014 because he had already started a family, and so his deportation would breach his supposed human rights. But then, when he's found guilty of paedophilia, the taxpayer not only foots the bill for his imprisonment for 3 years rather than deporting him immediately upon conviction, but then, when he's served his time, we're stuck with this criminal who doesn't warrant asylum because of his right to a family life, yet he's been granted it. This paedophile will now go back to the family which he has abused. This is not the first time we've discussed cases like this on the programme. Remember the Nigerian illegal migrant and convicted drug dealer who avoided deportation earlier this month because Nigeria wouldn't have sufficient mental health care services? This is the fault of the ECHR too. What about the Indian illegal migrant and convicted paedophile who avoided deportation earlier this year because it would impinge on his right to a family life? Surely paedophiles lose some of their rights? Doesn't that just seem fair? They are some of the nastiest criminals around, and they abrogate their rights by their crime. That's the whole point of the crime and punishment system. As a consequence of this Human Rights Convention is getting all muddled. What about the Syrian illegal migrant and convicted bank robber who won the right to stay in the UK in October on the grounds that he would be persecuted back in Syria, a result of the ECHR? Sir Keir Starmer and this socialist government have no plan to solve this problem. They don't really care about it because they think it's how we ought to be governed, giving in to higher rules of law than our own parliament. And these facts are all connected. They are all illegal migrants and criminals who avoid deportation, and we're not even allowed to know who they are. They're granted anonymity from the courts, and this seems to me to be even worse, that justice needs to be public. I understand if somebody has abused his own family, you need to protect the children of the family. But what about a bank robber and all these other people? We ought to get all their names wherever possible. On top of all this, it's the insult to the British people that the ever-growing conspiracy of silence that undermines democracy and prioritises the rights of foreign criminals against your rights to live in a country that ought to be safe and ought to have dangerous criminals removed. This great nation took 1,000 years to build, and it's being destroyed by an agenda of the global elite, of people who have forced an unaccountable bureaucracy-based order over a democratic one, an order that the new crony Attorney General values above our own rule of law. As Lord Howard told us on this programme last week, the best protection of our freedom is the right to vote. A representative democracy balances the difficult choices that have to be made. An unaccountable bureaucracy, through the ECHR and the Human Rights Act, does not. As ever, let me know your views via Rees-Mogg at GBNews.com. I'm joined by a friend of the programme, Fadi Farhat, the human rights lawyer, as well as my most incisive panel, Tom Pursglove and Amy Nicole Turner. Fadi, thank you again for coming in. It is getting really frustrating that nasty criminals who remain a danger, I think with this paedophile, they've admitted that he remains a danger, and yet he's allowed to stay in this country.
Yes, I mean, all these cases are still going through the system.
There are further appeals.
There are further appeals. And in some cases, the Home Office have been successful. So in relation to the Syrian bank robber, the Home Office successfully appealed to the upper tribunal, and that's been sent back to the first-tier tribunal.
Yes.
In relation to the chap from Congo, the sexual offender from Congo, he won his appeal, but again, the Home Office have successfully clawed it back. And in relation to the Nigerian drug dealer, he actually lost in the first instance, but has managed to appeal successfully on a technicality that the judge applied the wrong legal test and didn't quite get the right framework. So in all cases, we could still see the Home Office succeeding. And where cases are pending, I then fall back on the overall statistic on the grander picture. Earlier this year in the summer, the Home Office, the House of Commons Library, published a research briefing. And in that, we have the total number of appeals from April 2008 up until August 21. It's very interesting, April 2008 till August 21, because that straddles 3 sets of governments, the butt end of the Labour government,
yes,
the coalition government, as well as a purely Conservative government. And across those 13 years, migrants have won only 11% of cases where there's been serious criminality. The Home Office has been successful in 89% of cases. That, to me, would reveal that rather than providing a sanctuary for those who've committed serious criminality, the ECHR rather doesn't provide them with the protection that one believes. 89% of cases are won by the government.
But isn't there something else that we should be concerned about? That this is an enormous amount of legal activity for things that obviously ought to happen, that people ought to be deported from this country, and it should be a judgment of our law that says people who've committed these crimes go, rather than giving them these rights that allow them to stay, and that even 11% is 11% too many. We shouldn't be allowing dangerous criminals to stay.
No.
And we shouldn't have these endless court cases about them as well, which are a huge cost to the taxpayer and a strained court system.
It's a huge cost to the taxpayer, yes. But, I mean, even reading that paper with the 11% that are successful, I think the paper says that the 11% amounts to about 21,000 cases. Again, far too many. But the Home Office, even then, is successful in appealing about 6,000. So even 6,000 cases are shaved off the 21.
All right, that is still 15,000 people who are criminal who are in this country.
Yes, but for me, the wider problem is if 89% of cases are successful, and if the 11% that are successful on the side of the migrants amount to 21,000, that means the 89% that are successful are over 200,000. Yet we don't have 200,000 removals in that period.
So we need to be
the
removing.
enforcement, or the lack of enforcement, boots on the ground, is the bigger problem than the framework for me.
That is an extremely important point. Let me bring my panel in. Tom, I mean, this is an area you know a great deal about. Why are we not good enough at getting rid of people who've committed crimes?
Well, I actually think it's both of those two things that have just been touched on there. I think when you consider the enormous pressures that illegal migration puts on the department, you just cannot get away from the fact that this is enormously consuming of the department's bandwidth. It puts enormous pressures on the tribunal, and simply getting through these cases is a hell of a job. And when you also think about the fact that from a numbers perspective, that is enormously challenging, but also in all of the time that passes between a case coming to fruition and then being heard, often and invariably additional routes are put down, which then generate further grounds, and we go round and round, which is why Pretty and I were so determined through the Nationality and Borders Act to bring forward the one-stop shop to try and kick on and get through these cases more quickly.
But what you and Farley are basically saying is from 2008 to 2021, the British state was entirely incompetent.
Well, I wouldn't accept that, but I do think, and actually Dominic Raab, when we were in government, was very strongly arguing for the Bill of Rights. And I think one of the things that ministers could do now is have another look at whether increasing the bar through the Bill of Rights, as Don was proposing back then, could be helpful. I know and I recognise the arguments for leaving the ECHR. There's not a majority for Parliament on that front at the moment. But what I would think is that it would be sensible for ministers to look at that to see whether cases like those you've mentioned could be dealt with much more expeditiously.
Emmy, do you accept that foreign criminals ought to have lower rights than law-abiding British citizens?
I think it's really difficult, but I think the main thing is the ECHR didn't give those criminals more rights in any of those cases, because the ECHR was it's not duty bound with the UK law. It doesn't determine anything to do with UK law. What is the case in all three of those cases that you outlined in your monologue was a lawyer saying, I'm going to use the ECHR to make a case. And if they didn't use the articles from the ECHR, they would have used something else. It's just essentially lawyers trying it on. The ECHR has not actually given any verdict or said a word about any of these cases, and I doubt it even knows about these cases. So to say the ECHR has any role in any of these,
well, it's crucial because it's the legal basis. No, it's not, because it's the legal basis that they're using, and that before the ECHR came into British law, or the right of direct appeal to the European Court came in, people would have been deported without being able to go to a right to family life and things like that.
Because in common law there is things about family life that a lawyer would make use of. They're making use of the articles.
What level of rights would people have had prior to the direct appeal to the European Court?
So the Human Rights Act wasn't in force, but there are common law rights to a family life, and you could still cite the immigration rules and argue that if you meet the criteria of the immigration rules, then there's no public interest in the removal.
Yes.
There's still the concept of a decision being irrational in the public law sense.
And the sort of Wednesbury test.
Unreasonable.
Yes.
And if you have a family and you can say that I've committed this crime, but I've rehabilitated, and here's my family, and here's my children who are British citizens,
that was very much
then arguably
harder.
that could be Wednesbury
unreasonable, but
yes.
that was a very much harder barrier than under the Human Rights Act.
It's a higher barrier in the substantive sense.
Yes.
But I think what's being touched on by the panel in that answer is that the pleadability is still there. So the moment you have the pleadability to cite it, then you engage the court system. The moment you engage the court system, you engage the bandwidth. The moment there's a bandwidth problem, you're stuck in the same situation of the merry-go-round, and that's what we have here now.
You would have to exhaust every court in the land to get it to the ECHR. None of these cases would ultimately go to the ECHR. And if they did, they would probably get thrown out. Because in 2023, only one case from the UK was found in violation of the ECHR. So to keep putting ECHR in headlines about cases is really misleading.
It's the Human Rights Act that has led to these very large numbers being appealed, hundreds of thousands on Fardey's figures.
Exactly, and that's why I think actually having another look at the sort of Bill of Rights Bill proposals that we were talking about is exactly the sort of measure that could be taken in the short term to try and kick on from this and to make it easier for the courts to get rid of people from this country who are undoubtedly and often a danger to the public.
Well, I think we should get rid of criminals, but thank you to Fardey and my panel. My panel want to carry on arguing. That's what they're here for.